Hello, everyone. Welcome to this month's webinar, How to Avoid Lawsuits and Fines, Tips for Employers. The specially formatted free webinar is available exclusively for customers enrolled in our subscription services. I'm Stephanie Blicky, the Subscriptions Program Lead for Personnel Concepts, and I'm joined by my co-moderator, Leon Frierson, who serves as our Corporate Accounts Executive.
Hello and good afternoon to all of our attendees. For today's webinar, we will be discussing how important employment law compliance is in helping employers avoid fines and lawsuits. We will focus on key areas like wage and hour, workplace safety, and anti-discrimination policies. And after a brief discussion, you'll have the opportunity to consult with our attorney on these key workplace compliance areas in our live Q&A session.
That's right. So today's agenda includes an introduction of our guest attorney. At that time, he will provide us with an overview of government fines for non-compliance, how compliance can help employers avoid costly penalties in litigation, and the most common employee lawsuits. Next, our guest attorney will accept questions and answer them live, providing Personnel Concepts customers with the invaluable experience of engaging with a knowledgeable attorney on critical employment laws. And then before we leave, we'll provide some key takeaways from today's session, and throughout we'll be engaging the audience with poll questions.
Yes, and speaking of engagement, let's get started with our first poll. Today's webinar session is heavily dependent on audience participation, and to make the best use of our time, we're in search of timely and meaningful employment law compliance related questions to present to our guest attorney. So, to ensure that we are prepared to fulfill today's hour with helpful content, we need to know, what are you most interested in learning about during today's webinar? And we want you to choose all that apply in this instance. Is it wage and hour and record keeping? Is it poster requirements and fines? Is it workplace safety and penalties, anti-discrimination policies, and or common employee lawsuits? Just a reminder, you want to choose all that apply for this this actual inquiry. And we'll give everyone just a couple moments to answer. Let's go ahead and close the poll. So it looks like the bulk of the audience would want to know about common employee lawsuits. It makes sense based on the subject that we'll be talking about today. And we're all across the board as far as wage and hour, poster requirements, workplace safety, and anti-discrimination policies. Well, good thing is we'll be touching on each one of those items today. And so I think you should have a very useful webinar. Thank you all for participating.
Yes, and as your Q&A session moderator, I'll be directing your submitted questions to our guest attorney. Just keep in mind your questions might be slightly modified just to ensure the best outcome for the session. The purpose of this webinar is to provide accurate and authoritative information on the subject matters being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your human resource professionals on specific matters pertaining to your business. Personnel Concepts, the webinar hosts, and our guest attorney are not liable for any errors, omissions, changes in law, or advice that lead to unfavorable outcomes.
Yes, and on today's webinar, we're hosting a special guest attorney to deliver guidance on the topic and answer questions in today's Q&A session. Our panelist has frequently been featured as a guest speaker in our webinars. I'd like to welcome back attorney Jeffrey Fucci, who is a graduate from Vermont Law School with a dual master's degree in JD and serves as an in-house legal counsel to a diverse group of corporate clients. Jeff provides counsel on matters including labor disputes, employment negotiations, anti-discrimination, workplace policies, equity agreements, non-disclosure agreements, and general consultation. Today, Jeff will cover several employment law compliance topics, including posting requirements, OSHA compliance, record keeping, wage and hour, retaliation, and discrimination.
Thanks for having me, Leon and Stephanie, and thank you to all of our attendees today at the Personnel Concepts presentation. Let's begin with discussing the very important labor and employment posters that employers must display. In nearly every scenario, printed paper posters still remain an essential component of workplace compliance with federal laws. For this reason, I'm always advising my business clients to familiarize themselves with the long-standing United States Department of Labor, or DOL, we're going to talk about them a lot today, their requirements to post summaries of applicable federal labor and employment laws in the workplace to get those posters up. And also remember, there may be state and municipal requirements for posters as well, and we're going to talk about both of those governmental entities a lot today as well. As a general tip, employers must place posters where the notice can be seen and are conspicuous. And that's a legal term that means that everyone can see them in the workplace. Some areas that are likely to be sufficiently conspicuous as a matter of law are, for example, a break room, a copy room, or an employee cafeteria. Providing workers access to posters in this way ensures that the workers are informed of their rights under employment and labor laws which apply to them. Proper posting can also be used as an affirmative defense by employers in the event that they face a lawsuit. And I know from the poll, employee lawsuits are a big topic today with our groups. So it's good to know that putting up posters can be something you can use as an affirmative defense if you're ever brought to litigation. In other words, we trained our workforce, we advised our workforce, and they knew what their rights were. And that's an affirmative defense. But in the regulatory sense, there's also a lot of very concerning fines in terms of failure to post fines that could come with relation to the different types of posters. We'll talk a little bit about the federal posters right now and stick to those, keeping in the background that there's state and local posters in certain jurisdictions as well. So for these federal laws, including the Family Medical Leave Act, or FMLA, the price for noncompliance has gone up in recent years from $189 to $204. And again, that's for the noncompliance in terms of posting up posters and meeting the other requirements related to those posters. For the Job Safety and Health, it's the law poster, which is the OSH Act or OSHA poster. Those fines have risen from $14,502 to $15,625. So that's a very critical poster there to have up. For the Employee Polygraph Protection Act, fines have gone up from $23,011 to $24,793. And for the Equal Employment Opportunity Commission's Know Your Rights poster, and that's the EEOC poster that covers things like discrimination and the hostile workplace prohibitions that are passed down from the EEOC, which deals with all those federal laws that protect people's rights under the Constitution. The fine for noncompliance was just raised in March of 2023 from $612 to $659. Now, there's more here in the regulatory situation of fines that can come around than just dealing with whether or not the posters are posted. That's sort of the substance, sort of the procedure, but there's also a substance. There's also another aspect to it. The posting requirements can be different for every poster, and there can be even more rules and regulations attached. And here are a few of the following. The Equal Employment Opportunity poster and the Employment Polygraph Protection Act poster, along with some of these other federal posters we're talking about, have to be displayed and visible to all members of the workforce, including current employees and even job applicants that are coming to prospectively have a job. State-specific posters are also released, as I mentioned, for state agencies, and employers will be fined if they're not in compliance in terms of posting those. And in some of the bigger local areas, such as maybe New York City or LA, there could be posters with the local agencies that deal with job issues as well. So it could be perhaps federal, state, and local. Municipal and industry-specific requirements, ranging from anti-discrimination requirements to health requirements to county-specific wage notices, those may have to be posted as well. Certain posters, for example, OSHA's poster, have specific size requirements, and other posters have specific font requirements. And the poster requirements, in order to meet those, it's important to note that that the group that's here today might want to know that Personnel Concepts actually has a lot of these posters that are available that meet these requirements and are compliant. So that's good news, because that'll save you the trip of having to go find them yourself, and you'll know that what you're dealing with is compliant for your workforce the way that we're talking about. Now, there's an issue that comes up a lot that people are curious about. My workforce is changing, especially after COVID. I've got some hybrid people, fully remote people who've never even seen this inside of the office. What are the requirements in terms of posters in that way? And according to guidance issued by the DOL, a prominence notice on the employer's website can be a supplement, but not a substitute for physical posting of the posters. So if you have any employees that still come to the physical workplace, you have to make sure the copies of those posters are up and that they're conspicuous, like we've talked about. Now, there may be some exception to physical posting requirements, and those might be available in a handful of cases, and those cases might include, as I mentioned, the worker who's never seen the inside of the office, the fully remote worker, sort of a post-COVID trend that's continued. Another situation that may be an acceptable exception is when employees customarily receive information via electronic means, such as email or perhaps access to a cloud system where all HR documents and policies are stored. or perhaps a shared drive where employees can access all of this information. If you're going with those types of cases and you're trying to rely on those exceptions, I always advise my business clients, make sure that you periodically are sending notices to your employees if you're updating any of those policies. And also consider that you want people to perhaps check a box or otherwise provide their confirmation of their assent that they've had access to those posters and policies, that they've read them, that they understand them, and that they did this on a certain date. So you want to make sure that you keep a record in terms of that compliance. If an employer has both on and off-site workers, the company, if they've got this mix of workers, can only supplement but can't completely replace the hard copy posters with the digital varieties. In light of the concerns that DOL has expressed for poster compliance, employers definitely want to consider taking a closer look at their current practices to see if they're displaying the correct, applicable posters in the proper locations where all employees or applicants can see them. Of additional note, the DOL's guidance applies only to federal notice and posting requirements of its own agencies. And as we mentioned, there could be state, local posting requirements related to posters as well. Talking a little bit about audits, inspections, people showing up from the government to check regarding these posters. Audits can be relatively rare. This may be due to manpower that the government agencies have, and a lot of businesses they have to regulate. But audits do happen, sometimes surprise audits, and fines can go up with subsequent offenses. If a government investigator visits a job site location and sees outdated labor law posters, or perhaps no law posters at all, this could even trigger additional investigations to see if other compliance matters are being handled by the company or if they're slipping through the cracks. This could make the business in question a target for governmental scrutiny, and it could raise those costs for the business very quickly.
Great. Thank you, Jeffrey. And Personal Concepts is committed to helping your company stay in compliance with these posting requirements. Our compliance specialists are available to answer your questions. Our phone number is being posted in that chat window too for customer service in case you have any questions in regards to the posters or need an audit or anything like that, they can help you. And with that, we'd like to open up to another poll question. Leon?
Yes, let's do it. And then as we move into our next topic, we would like to know more about your specific interests so we can continue to provide you with helpful information. So please select all that apply once again for this poll. And we'd like to know which safety topics are most relevant to your business. Is it emergency action plans, personal protective equipment, handling of hazardous materials, industry-specific requirements, or is it slips, trips, and falls prevention? Remember to select all that apply. We want to make sure we touch base on everything that's necessary. Give everyone just a few more moments and let's go ahead and close the poll. Let's keep it moving. All right, with that, emergency action plans take first place there. We have a tie for industry-specific requirements and slip, trips, and falls prevention. And then, of course, there are some people that are interested in handling of hazardous materials and PPE. So thank you all for your insight. We'll keep these responses in mind as we develop more subscriber content.
Yeah, thanks so much. And let's move on to our next topic here. Jeffrey, what can you tell us about complying with OSHA's rules and regulations?
Sure, Stephanie. One of the ways that the Occupational Safety and Health Administration makes sure that those rules and regulations are complied with is by monetary penalties, which were raised in early 2023 to as high as $15,625 per violation for the various classes of violations that include serious, other than serious, and posting requirements violations. Failure to abate violations, another category, can lead to penalties of $15,625 per day for the date that the violations continue beyond the abatement date issued by OSHA. Violations that are found to be willful or repeated, and that has to do with intent related to the violations, those can rise to as much as $156,259 per violation, so over $150,000 per violation. These penalties may be adjusted up or down by OSHA based on a sliding scale and such considerations as the seriousness of the particular violation, the employer's previous history with violations, the size of the business, and the good faith that's been shown in terms of compliance by the employer. An OSHA violation occurs when a company or an employee willingly or even unknowingly ignores potential and real safety hazards. The top OSHA violations logged every year include fall protection, hazard communication, ladder safety issues, respiratory protection, scaffolding issues, lockout and tagout issues, industrial trucks, training related to fall protection, PPE, and failure of safety with regard to machine guarding or very dangerous area guarding. Violations are categorized by OSHA as what they call serious violations when an employer knows or should know of a condition or a situation that has a definite chance of causing serious injury or death but does not remedy the situation. Willful violations are intended violations of OSHA's rules and regulations that show blatant disregard for employee health and safety. If an employee loses their life due to a willful violation, and tragically if that happens, the responsible employer may not only be fined but could also go to jail. And that's not even including the possibility of civil litigation that might be brought, for example, by that employee's family or next of kin. If an employer is cited for a particular violation and a subsequent inspection reveals another identical or very similar violation, OSHA inspectors may cite the employer for what's called a repeated violation, something OSHA does not take kindly to, reserving some of its highest fines for repeated violations. Penalties can depend on the severity of the infraction. Meanwhile, OSHA also has the discretionary power to issue citations instead of violations, and these are lower levels, sort of like a warning instead of a ticket when you're speeding. And these are for situations where OSHA does not really OSHA finds that the employer hasn't really put anyone in harm's way. In such cases, instead of issuing a fine, the agency may give the company, as we've said, a citation. And those are the different kinds of situations that can occur with OSHA. It's very, very important to be aware of that. And that's great because the group wants to hear about hazard plans. And a lot of these issues cover hazard planning in the work.
Yes, yes, and thank you for breaking down OSHA's categorization of violations, Jeffrey. Could you also cover a few OSHA compliance tips for our employers?
Sure, absolutely, Leon. And employers, even though today we'll be providing materials from this lecture, also think about maybe taking a few notes here because we put together some top tips for OSHA safety in the workplace. Certainly, one way to avoid OSHA violations and citations is proper training of everyone who's in your workplace, who's under your control. More than 100 OSHA standards have requirements just related to the training aspect of the employee day-to-day in the workplace and the health and safety aspects of the employee's jobs. Some standards also require employers to limit certain tasks to employees who've only had specialized training. Some of the topics all employers must cover during the training include fire prevention plans, hearing protection, the storage of hazardous materials, personal protective equipment or PPE, and materials handling. OSHA also has specific training requirements for employers who participate in the maritime, agricultural, or construction industries. Providing workplace training is a definite step that I'd recommend in the right direction to ensure OSHA compliance and to avoid fines down the road. Overviewing these and some of the other items related to OSHA, here are our top 10 tips for OSHA compliance in the workplace. Know where to access the OSHA Act poster, as well as the OSHA Act itself and all of the related regulations at all times. Make sure the OSHA Act poster is properly displayed in terms of the requirements that we talked about by law, in terms of its size and in terms of its font and things of that nature, of course, also in terms of its information. Ensure that your business has a hazard communication program in place. Report workplace injuries and illnesses appropriately. When we say appropriately, that's going to depend on what OSHA's particular standards, and standard is the legal term related to the specific industry and the specific type of OSHA issue that's covered. OSHA is going to have requirements for reporting related to each of its standards related to what happens. So perhaps reporting is going to be to OSHA, perhaps it's going to be to the local government that has authority over that particular issue, or perhaps it's going to be to the insurance company or to the hospital or whatever the case might be. Of course, keeping accurate information on hand from the moment there's an incident does protect you, the employer, but you want to also make sure that the information you're keeping aligns with what OSHA expects, because they may come around later asking for certain information, and you want to make sure that you have it readily accessible. You have to control, employers have to control hazardous areas in the workplace, such as heavy machinery or areas where high voltage electricity can be exposed. And the best way to do this is with a lockout and a tag out program, where those places can't be accessed without the right kind of key. A person is accountable for having access to the key, and then they return the key when they're done using it. It's important to have an emergency action plan in the workplace and to update it routinely. It's important to have a fire prevention plan in the workplace and to update it routinely as well. Have an electrical safety program on site, restrict entry to hazardous areas, and ensure that employees are using company-provided PPE as they're directed to do. And make sure you take a check on that PPE and make sure it's up to date, equally dispersed amongst your workforce for those employers who need it, working and safe.
All right. Thank you for providing key OSHA compliance tips. Jeffrey, just to kind of change directions here so we can get over all of our topics, what can you tell us about employer record keeping requirements?
Yes, Stephanie, very important. Multiple federal agencies have requirements for employers regarding record keeping, and this is going to have to do with the different federal agency and the different laws that each federal agency oversees. The biggest one we're going to talk about is the EEOC because they're responsible for basically enforcing all human rights related laws that workers have. So anything that we'll talk about later, such as Title VII, the ADA, the Pregnancy Discrimination Act, all of that's going to fall under the EEOC, and often other laws that other agencies will enforce even intertwine with the work the EEOC does. The EEOC has local offices in every major city and many offices across every state covering whole regions. So the EEOC, or the Equal Opportunity Employment Conditions Regulations, they require that employers keep all personnel or employment records for 1 year. If an employee is involuntarily terminated, their personnel records must be retained for 1 year from the date of termination under the EEOC's record-keeping requirements. Under the Age Discrimination in Employment Act, or the ADEA, that's a federal law designed to protect employees, by the way, who are age 40 or older from age-based discrimination. Employers must also keep all payroll records for 3 years. Additionally, employers must keep on file any employment benefit plan, for example, pension and insurance plans, although in these days you might see a lot too related to stock option plans or equity ownership, and any written seniority or merit system for the full period that the plan or system is in effect, and then for at least 1 additional year after any such plan or system is terminated. Under the Fair Labor Standards Act, the FLSA, employers must keep payroll records for at least 3 years. In addition, employers must keep for at least 2 years all records, and this includes wage rate records, job evaluations, seniority and merit system records, and collective bargaining agreements if you deal with any unions. They have to keep all of these in place, any records that explain the basis at all for paying different wages to employees of the opposite sexes working in the same establishment. The FLSA requires that records being maintained include certain identifying information about employees and data related to the hours worked and the wages earned. The law requires this information to be complete, accurate, and up to date. Now, these records we're talking about, they have to be open for inspection by government representatives at either the federal, state, or local levels, who may ask the employer to do such things with the records as make summaries, extensions, computations, or transcriptions, so that the access can be provided to those government agencies of the type of key information that they're looking for. So that data has to be comprehensive, and it has to be something that you might even have to make other documents out of it to provide. And that's part of the investigation process that these agencies that have continuous oversight of an employer may ask for. The records can be kept at the place of employment, the centralized workplace, or a central records office. And it's important to note that in the current context, keeping these records in a cloud system or perhaps in a shared drive or some other readily accessible centralized electronic database would also likely meet this requirement. And I see this with employers all the time. They're converting over their traditional paper systems to more modernized digital systems. In modern times, you could probably use a digital or cloud-based site, and this would be sufficient as well. And the most important takeaway is that these government agencies want you to be able to provide them this information within a reasonable time frame, and that the information has to be reasonably accurate, complete, and up to date. Additionally, if an employee brings a complaint to the EEOC, the EEOC will issue a notice of charge form that an employer will receive that will explain the agency's record-keeping requirements once again. Generally speaking, an EEOC charge will state that a company should retain personnel or employment records relating to the issues at hand in the investigation as a result of the charge. These include reports related to the charging party or the witnesses to the incident, or even other persons alleged to be aggrieved or involved, and all other employees for a specific duration of time related to the charge. So in addition to what's already statutorily required, the EEOC has the discretion to issue specific timeframes in their charge notice for specific types of information for specific individuals. And that's what you really see when the EEOC starts to ramp up efforts and launch an investigation and get involved. That said, not every investigation leads to what they call a notice of intent to sue letter or a right to sue letter. Some of those end with no issuance of a right to sue letter. And then at least in terms of the EEOC, an employer can be relatively confident that they're going to be off the hook for a lawsuit. Nevertheless, once a charge is filed, the records must be kept until the final disposition of the charge, or if they get one of those right to sue letters, until the lawsuit based on the charge has been fully adjudicated in the competent court.
Great. Thank you for that dive into specific record keeping requirements under federal law. And as a subscriber to our audience, you have access to our digital workplace compliance library. And depending on your subscription tier, you can get access to forms, guides, checklists, and sample policies to help with compliance. So you can contact customer service if you have any questions about that. And with that, we'd like to open up to another poll question. Leon?
Yes, our next poll question actually is directly related, as we'd like to know about the forms our top tier CMS subscribers have access to, so we can provide more information on similar topics. So please let us know, and of course this is for CMS subscribers. Which employee record keeping forms would be most valuable to your business? Please select all that apply. And I'd like to correct myself. It's not for CMS subscribers. We do have these forms available to them, but we want to know from everyone in the audience, what is most valuable to your business? Is it attendance record forms? Is it employee separation forms? Is it a request for an accommodation form? Is it an EO incident report? Or is it an overtime request and approval form? And please just select one. Actually, we like to just to know what would be the most important and most useful for you. Go ahead and select one when you're able to make that decision. Hopefully you've all chosen one, and we'll go ahead and close the poll now. All right, well, it looks like the leader is the employee separation form. I guess that is somewhat of a sensitive topic, very useful for employers. And then tied at second place, we have attendance record forms and EEO incident form. So thank you all for your responses.
Great, thanks so much. And moving on to our next topic, Jeffrey, what can you tell us about the most common employee lawsuits and how to avoid falling prey to them?
Under the Fair Labor Standards Act, a federal law, and similar statutes put into place by the state legislatures, employees are entitled by law to receive overtime compensation at a rate equal to 1.5 times their usual wages for time worked in excess of 40 hours a week. Though state and federal law identifies various groups of employees who are exempt from this requirement, non-exempt employees may recover damages in court if their employer fails to pay them at that overtime rate. Employers are also prohibited under federal law from retaliating against employees who report alleged wage violations. We're going to talk about retaliation in much detail in just a little while. A wage and hour lawsuit could begin with claims under federal law, continue to allege violations of companion state wage laws, and finally include additional claims under sets of laws for retaliation. These types of lawsuits can become very expensive for employers, with plaintiffs seeking compensatory damages, punitive damages, courts costs, attorneys' fees, and other relief, not to mention negative media exposure and impact on a brand that can come from publicly filed wage and hour lawsuits.
And Jeffrey, along with the wage and hour protections the FLSA provides, can you give a brief overview of how employers can distinguish between a position that is non-exempt and one that is exempt?
Great question, Leon, and one that I get and I think the federal agencies get all the time. In addition to providing the roadmap for employees to protect their right to overtime pay, the FLSA also sets forth the type of employees who are considered to be exempt employees, in other words, exempt from entitlement to overtime pay. A common question attorneys like me receive from their business clients all of the time is whether the various titles and roles within their company will fit one of these exemptions. The FLSA provides a fairly lengthy list of categories that are exempt, such as bona fide executive, administrative, or professional employees, certain agricultural workers, employees of small newspapers, and certain individuals who are informally employed as domestic caregivers. However, the law looks to more than just titles and considers the totality of the employee's actual day-to-day working situation in determining whether or not an employee should be exempt. A link to the Department of Labor's fact sheet number 7, a helpful resource for companies to use to determine the status of their workers and also to create their roles to achieve the desired or preferred status of those workers, is going to be provided by the Personnel Concepts team as part of this lecture, this presentation, I should say. Not a lecture.
Yeah.
We're doing Q&A pretty soon.
Definitely. It's right. It should be right there in the chat any moment. And so thank you so much, Jeffrey, for the critical reminder to ensure that all employees are classified correctly on and how the law tests those exemptions. And what can you tell us? Can you tell us more about lawsuits alleging retaliation specifically?
Oh, sure, Stephanie. That's big. I mean, retaliation can actually sometimes overshadow the underlying complaint. Sometimes they say that The cover-up is worse than the crime. Well, in the sense that these types of civil and rights-based lawsuits in the workplace, sometimes the retaliation charge is worse than the underlying violation. We have data on this all the time that comes from the Equal Employment Opportunity Commission, which we talked about before, which reported that retaliation is the most common alleged discrimination finding in most cases that are brought before that agency. Under federal employment laws, a manager may not fire, demote, harass, or otherwise retaliate, and that's a legal term, against any individual for filing a complaint of discrimination, participating in a discrimination proceeding, or otherwise opposing discrimination in some way. Other federal laws also have anti-retaliation protections built in. Collectively, and of course at the state level too, a lot of these laws have more complex acronyms and names. These are called whistleblower laws. Whistleblower laws exist at the federal, state, and local levels. When it comes to retaliation by managers, the EEOC advises that individuals are likely to retaliate in situations where the accusation is very serious, the accusation will negatively impact future relationships with other people in the workplace, the accused feels they are being judged, the accused believes their job is in jeopardy, or there's reason to believe that the accusation will harm the perceived employability of the accused. And this is interesting because, as I mentioned, the EEOC actually put out this guidance recently, which we're talking about right now, and they tried to get into the heads of the retaliation people, the players who are involved in the retaliation sort of rubric, because they see a lot of these things come in front of them. So they talk a lot in a document that recently came out about why do employers and managers retaliate, and what are they thinking when they do that, and what are even the organizational factors in a company that can influence retaliation. And they came up with some of these as well. They said that retaliation was shown to be more common in workplaces where there was a lack of administrative policies and training discouraging retaliation. There was an authoritarian management culture. There was an overly hierarchical organization where rank or organizational levels were prized and coveted. There were high levels of task-related conflicts amongst the workers. There were reward systems and structures in place that promote competition amongst the workers. And there's a culture in place that where the ability of the accused to isolate the accuser is very prominent. So where somebody can be, who makes an accusation or brings a problem forward, they can be singled out and humiliated, reprimanded, or otherwise retaliated against, is what we're talking about here. And those are the things that the EEOC has recognized as really what we might call toxic workplaces in terms of retaliation.
Thank you, Jeffrey. And now that we know what may lead to a retaliation claim, what are some ways employers can avoid retaliating in the first place?
Yes. Well, there's a number of ways employers can sort of get their heads right to avoid the pitfall of retaliation. Training and circulating educational materials like the ones available through Personnel Concepts, those are things businesses should invest the time and resources in. I'm always telling my business clients that investing in that type of training, those types of materials, even participating today in this presentation, all of those things, they will certainly cost less later than the cost of the lawsuit, especially in terms of the exposure that can come from these very public lawsuits as well. Plaintiffs' attorneys are looking for the lawsuit that makes the biggest impact across a variety of ways, both in the damages and also the exposure, because that ratchets up the damages for the plaintiff who brings the lawsuit. So it's worth the investment of time at the front end to avoid the potential losses and costs at the back end. Also, using these items builds a much better internal culture, which doesn't lean into workplace retaliation. Frankly, that's a place that people are going to want to work, a place where they feel like they can speak, they can be heard. And if they are heard about something that concerns them, especially something that's rights related, they're not going to be retaliated against for doing that. So in addition to training education, employers should also learn ways to take a step back to consider their reactions in these situations. Just the slightest noticeable change in behavior of an employer towards an employee after a protected complaint is filed can be seen as retaliatory. The employers would want to replace their knee-jerk reactions in these type of situations with instead best practices. And the EEOC has provided some additional tips to frontline managers and to employers who are receiving complaints for their employees. These tips include the following. Avoid publicly discussing employee allegations. Do not share information about protected activities or the complaint with any other managers or subordinates. Kind of keep that information in the control group or the focus group of the company, the higher level, the C-level people, so that it doesn't leak out and cause other people to act differently, because that could be seen as adverse and retaliatory. Be mindful not to isolate a complaining employee from others. Avoid reactive behavior such as denying the employee information, equipment, or benefits provided to others who are performing the same or similar duties. Do not interfere with the administrative or legal processes. Provide clear and accurate information to administrative or legal requests for information, and do not threaten the employee, witness, or anyone else involved in the processing of a complaint. I just want to go back for a second talking here and focus on one particular issue, because this happens all the time. Not only do you want to avoid the reactive behavior of intentionally denying the employee things in the workplace that are normal for their job, but as an employer in a company, you also want to avoid doing anything that could be perceived as that, and also doing those things that may just seem routine, that if a person has indicated to you that they have a complaint and that they're getting ready to go forward with that complaint, and perhaps this might even become litigious, there's even things you might take for granted in the workplace that you might be doing that could be perceived as retaliatory under the circumstances. An example I like to talk about that I've seen many times, because I've had a lot of governmental clients over the years, is the police officer who files a end of career failure to promote type claim that has some retaliation tied into it. And then what happens is, just by normal operation of the police department, the police officer ends up with a bad beat, or driving a car that's old, one of these cars that has a radio that doesn't work, or the window doesn't roll up, or something else. These might seem like common things, the assignment of a police department of tasks, responsibilities, and tools, but they always get added to retaliation complaints. So if you think you're heading into a place where an employee is starting to become litigious, or they feel that something has been done to them that's wrong, you have to be very careful as an employer to not make any changes to their day-to-day operations at the workplace that could be seen by them when they're in that mode as being retaliatory or adverse, because these kinds of complaints, as the EEOC has identified, the complaint one thing, but the retaliation claim can be bigger, it can overshadow it. So you want to be very careful once you're on notice of a complaint that's going on, of the things you do after that. You have to let the employee keep working, but you want to be very careful not to do anything that could be viewed negatively. So if you almost sort of in your mind as an employer graph it out, is the thing that I'm doing positive, neutral, or negative? You don't want to be on the wrong side of neutral. So try to do neutral or positive things in reaction to the employee's day-to-day workplace to avoid additional actions being sort of attached to the initial complaint and seen as retaliatory.
Thank you, Jeffrey, for those key tips. And I just want to take a moment to remind all of our attendees that the slideshow for this presentation is attached in GoToWebinar. It can be downloaded for note-taking or for reference later. And then, just so moving on to our final topic for this webinar before we get into the Q&A. Jeffrey, what can you touch on lawsuits alleging discrimination or failure to make reasonable accommodations?
Sure, and we've talked about these before, Stephanie, in more detail when people have attended the presentations, but we'll go over them kind of quickly and leave room for the questions. A number of federal protections can form the basis for employee lawsuits and should be on every company's radar at all times. Here's a brief overview that we'll provide today for our audience. Some of these laws include Title VII of the Civil Rights Act of 1964, which states that employers may not deny equal employment opportunities to, or treat any person unfavorably because of, their racial group or perceived racial group, ethnicity, country of national origin, personal characteristics or cultural practices associated with race, or their marriage to or other intimate association with someone of a particular race or color. Under Title VII in the Code of Federal Regulations 29 CFR Part 1605, employers also may not treat employees or applicants more or less favorably because of their actual or perceived religious beliefs, and with limited exceptions, their religious practices. And this is important because that doesn't just include traditionally held religious beliefs from religions that we're all familiar with, but that could be actually any sincerely held moral or ethical belief. This came up a lot during COVID, where employers saw a lot of different kinds of requests for waivers from the inoculations and the vaccination statuses, and people had certain kinds of beliefs about the vaccination that weren't necessarily attached to traditional religions, but were still sincerely held beliefs. That was a time of great caution amongst employers. We've also got under Title VII, the Pregnancy Discrimination Act, which protects and covers women in the workplace who are pregnant, and also all women who could become pregnant. So a relatively wide age area of women, and that protects them from discrimination on the basis of pregnancy, childbirth, or related conditions. The Age Discrimination and Employment Act makes it illegal to discriminate against any employer applicant who is 40 years old or older. The Related Older Worker Benefits Protection Act of 1990 strictly prohibits denying benefits to older workers and places specific time requirements on any waiver of rights in settlement agreements. Also, you'll hear settlement agreements sometimes called separation or severance agreements. That's a form of settlement as well. And if you're dealing with a worker who's over age 40 and you've had either your legal counsel or your HR representative draft these agreements for you, you'll often see there's something in there that talks about how they have a revocation period, the employee, where they can turn back their revocation after they've signed the document, and the document can be nullified and things can move forward. That's an extra amount of time that's added to those types of severance and separation situations to give workers who are over 40, additional time to reflect upon the choice they've made and make sure that their rights are adequately protected. Another big law is the Americans with Disabilities Act of 1990 and its amendments. This prohibits discrimination against people who are qualifying with disabilities, either people who actually have the disabilities, who are perceived as having the disabilities, or have a recorded history of having disabilities. Employers must provide reasonable accommodations to these persons unless the accommodation causes the employer something that's legally called an undue hardship or an undue burden. And this is in light of the employer's size, financial resources, and business operations. Documentation with the ADA, as we've discussed before, is incredibly important in the conversational process to see what accommodations can be provided versus what burden would be placed on the company. In addition, state and local anti-discrimination laws can cover employers with even just one employee. Meanwhile, harassment or the creation of a hostile workplace can apply to any of the federal laws I've just listed, as well as the state and local laws. It is generally defined as unwelcome conduct that is based on race, color, ethnic origin, nationality, religion, sex, pregnancy, age of 40 or older, disability, gender, gender expression or gender identity, or genetic information or any other legally protected characteristic. Harassment reaches a level of being unlawful where enduring the offensive conduct becomes a condition of continued employment. The conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. The harasser can be almost anyone in the workplace environment, including the victim's supervisor, a supervisor in another department or area of the office, a coworker, or even a client, vendor, or customer.
Thank you, Jeffrey. It's always helpful to have a reminder of the several anti-discrimination laws at the federal level, as well as what constitutes harassment. In addition, could you address some ways employers can prevent discrimination from occurring in their own workplaces?
Yes, here are some key tips for avoiding discrimination lawsuits from employees. Adopt clear and meaningful anti-harassment and anti-discrimination policies. Conduct periodic training for your workforce, management, and HR personnel. Update mission statements that emphasize the company's commitment to a workplace free from unlawful harassment and discrimination. Host employee forums periodically to explore whether any discrimination or harassment is occurring.
Thank you so much for covering common employee lawsuits and how proactive compliance can keep employers on the right side of employment law. And the time has arrived for us to connect our audience with our expert here. Stephanie, will you kick us off with some important info on how to participate in today's Q&A session?
Absolutely. So to participate in today's Q&A session, I just want to encourage everyone in attendance to submit questions by using the questions feature in GoToWebinar. You can also pose a question through our webinar staff by using the chat window. If you'd like to pose your questions directly to the guest speaker using computer or telephone audio, use that raise hand feature in GoToWebinar and we'll coordinate with you on your request. We'll do our best to get through the most relevant audience questions for today's Q&A session, but all unanswered questions will be submitted to our attorney panelists for responses and sent to you via email. So don't worry if you don't get your answer today right now, we will get them to you within the next week. So let's take a look at our first question. We will have them on the board here for reference. So Jeff, we don't have any of the suggested rooms like a break room, coffee room, or cafeteria, and most of our employees work mostly online. What might a conspicuous location to post look like?
Okay, that's a great question. That's a great question. I'm thinking of that as I answer it. Yes, of course. When I said things like the coffee room, I think I was dating myself a little bit from my first time as an intern, perhaps 20 years ago in the workforce. It probably may not be a coffee room in the modern technology, and you probably don't want people running around your server room. So, what is the conspicuous location? There's a few ways to consider that. You mentioned that your employees are working mostly online. If that means they're in the office and they're working mostly online, in other words, they're sitting at the computer in their own individual spaces most of the time, the proper place for physical posting would be whichever place is a place where the employees are most likely to gather or to pass. So again, going back to that version of my interpretation of this question, I would say that perhaps if you had a hallway leading to a place that all employees had to go, for example, the bathroom or an elevator, that would be a good place where you could post the posters, or perhaps something that accessed a refrigerator, something else that's a utility that everybody has to get or pass by. That's assuming that they're online and they're at the workplace. If what you mean is they're working online and they're in another location, in other words, they're off-site at home or someplace else, then in that case, if it can be shown that that's almost always the case for those employees, then being able to post that information and share that information with them in a digital context is most likely going to be accepted at this point by the various federal agencies. If you have a worker who's completely remote and who has never been in the physical office, it doesn't seem like they ever will be in the physical office, then a digital representation of this information for the posters is fine. What does that mean? It means that you want to have the posters, like the ones that are provided by Personnel Concepts. You want to put them in a place where the employees can see them, and you want to make sure that you email those employees a link saying that they have access to those posters, that they agree that they have access to those posters, and that they agree and accept that they've read those posters and understand them. You can do that through a cloud drive. You can do that through a shared drive. You can do that by putting it on a website of some kind, although it's more important that that information faces inward to your employees than outside to the world. So if you have an intranet, you could use that. Again, the distinction would be whether or not the employees are in a physical space or the employees are completely remote. The only way that you're going to be able to get away with the exception of just the online posting is if the worker is completely remote. Otherwise, it's very important to still have them physically posted. If completely remote, those digital ways will most likely work as an exception.
Okay, thanks, Jeff, for answering that. And just for our audience knowledge, we do have digital poster packets as well for those employers that have fully remote workers. So you can contact customer service if you have any questions on getting that for your remote workers. Let's move on to our next question here on the board. We lease space on Sundays. I think this is a very similar question to the last one. Yeah, we lease space on Sundays for our church to use, so as temporary occupants, we cannot put up the posters. Can we just post them online?
That seems to be a question where the church, I guess the church is the employer and the space is only used temporarily. So it is a similar question, Stephanie, but it's also good because we're talking about any people who rent a space, right? It doesn't have to just be the church. It could be any employer who's using some other party's space, which we see all the time in rented workspaces and shared workspaces. In those situations, I am going, if you don't have the right from the place to put up the posters that we're talking about, then I would say that you would probably want to treat that workforce as remote and then go through the process I described before, which is make sure they have access to them and make sure they've signed off on the fact that they have that they've read them, understand them, and acknowledge the acceptance of them. Because even though you may all be in a place, that place isn't yours and you don't have command over it. Also, if you were making an argument to any of the agencies that would review this, that maybe would do the audit that we talked about before, the right argument to make there would be, number one, we don't have control of the space, and number two, because we're only here temporarily, we can't even ensure that they would be adequately reviewed with the short time frame that we're here. So we took the initiative on our own to go ahead and make this information available to our workers digitally because we wanted to ensure that they got it and that they understood it. And since we're only here temporarily, we couldn't ensure that in this kind of space. And that makes you sound more like the good guy than the bad guy.
All right, thanks for answering that, Jeff. Let's see what the next question we have on the board is here from our audience. Referring to record retention, is the phrase personnel records considered an umbrella term for all records or limited to specific records within an employee's files?
That's a good question. What generally tends to happen in the sense of the regulatory and litigation-based worlds is that the idea of personnel record is not always necessarily a legal term that's defined somewhere in a statute, and I don't think it's really defined specifically in a statute here, but I can tell you from the legal world what happens when people are looking for personnel records in the context of an investigation or a lawsuit. It's everything. It's anything related to the employee's time at the company that's ever been documented outside of, I would say, their work product. So personnel records wouldn't include the deliverables they produce for the company. Those are a different kind of thing. Those are the company's intellectual property. They're using those all the time. They're changing them and stuff. That's not the personnel records, but anything that ever involved the company taking any action towards the employee from womb to tomb would be considered personal records. So when they come in, the documents that the employee fills out on intake, the W-9s, the I-9 stuff, the background check stuff that comes around, anything related to performance review, anything related to communications for days off that were in writing, payroll documents, all of those things qualify as personal records. And I'm going to guess that we're not going to see another question like this, but we might. I'll just take this chance now, just say something that's useful to everybody. The thing about the retention issues with the various government agencies, we can fine tune it and say what each agency and each law requires, as we did today. But as a general rule, 3 years is a good amount of time to keep all of the records in all of the personnel records we're describing here. If you look back today at the materials, you'll see that there's a little bit of different requirements for every different agency, but the highest and best practice is going to be the years from the time of termination of an employee. That's going to be what's really a good idea in terms of retention. You can drill down a little bit more based on the specific law or agency, but the average is going to be 3 years. And if you follow that practice, you should pretty much be in good shape. Where does that number come from? Who knows? But in most lawsuit situations, usually people that bring lawsuits for types of actions, there's usually something called the statute of limitations. And usually the statute of limitations for these types of lawsuits will not extend past 3 years for employee-based lawsuits. So if you keep the documents for 3 years, you're likely to have what you need in the off chance that somebody, or on the occasion that somebody brings a lawsuit.
Thanks, Jeff, for answering that. That's usually what we recommend as far as old posters. I think I saw a question there as well about how long to store old posters for. We usually recommend in case of an audit 3 years as well. So I guess that's where that number comes from. So good to know. All right, let's put another question on the board here. Can you keep any medical information in the personnel file, or does it need to be kept elsewhere?
Oh, that's an interesting question. That's probably a HIPAA question, partially, and also an issue of privacy data, which gets us into HIPAA, which is the Privacy Act. I may have to get back on that question, but I'm going to generally say, based on my experience, in terms of segregating that information out as a separate file, a better thing to do might be to indicate its sensitivity or its confidential nature within the personnel file. I'm not exactly sure what you mean exactly by medical information, because certain types of medical information may not actually ever come under the employer might not have that information. I mean, really detailed medical information. But if you're talking about things like an employee's request for time off based upon a surgery or something related to a disability, those types of things generally will be included in the personnel file itself, but they'll usually be indicated to be sensitive or confidential in some way, so that if somebody's going through it who's not on a need-to-know basis at the highest levels, they probably wouldn't access that information. Very extensive medical information, it shouldn't usually be in the employer's control. They shouldn't be really, I don't think, involved with that type of thing. And HIPAA doesn't really usually envision the employer too much to be one of the business associates or the primary entities that are dealing with the medical information. That's usually medical providers. I understand there could be exceptions to this, but again, if you see something in it that looks like medical, which is going to be requests for time off, requests for accommodations under the ADA, make sure that information is segregated out, just like you would perhaps treat a social security number, because it is or credit card number or bank account number, because it's highly sensitive and does have personal implications. It should not be easily accessible. And again, going back to the digital context, you could password protect that or encrypt that so that the average person in the workplace wouldn't have access to it.
That's a good answer. Thanks, Joe. And if you have a further question on that as well, you can put it in the questions box, and Jeff can get back to you later when we send them out via email. Let's put another question on the board here. Are we liable for providing PPE to our employees? If so, are we responsible for the cost of PPE, personal protective equipment?
I love this question. This is a question where, of course, employers want to save money on costs. So I frame it carefully by saying there's a very good likelihood, me speaking as an attorney, that if you don't do the PPE the way that I'm suggesting, you could face more costs on the back end. Are you liable for providing all the same PPE to all of your employees? Employers do it a variety of ways, of course. In the practical sense, there are many employers who require their employees to bring certain kinds of tools to the trade. There's a lot going on there with that from a legal liability standpoint, especially because we're talking about life-saving things like breathing masks, eye protection, and perhaps other kinds of clothing that's flame retardant or guarding or something else. My recommendation is the employer should provide the PPE, and the employer should check the PPE to make sure that it's updated and working periodically, and they should record that and document it. I realize that can be a cost. I'm not insensitive to that, but here's what the other costs could be. Couple things. I'll just go through the ones that come to mind right off the bat. First of all, somebody could get hurt or killed if they have the wrong kind of PPA and the checks aren't frequent. The likelihood that that might happen increases when the person comes to the job with their own PPE because you left it to their own devices. Things can fall through the cracks, like I used that expression earlier. They can happen a lot quicker when the employees are all up to their own to bring in their PPE. Another thing that can happen, we've talked about retaliation lawsuits today in the context of what's considered to be an adverse employment action. I gave everybody the example of the police car that doesn't run so well, or the beat that nobody wants to walk in the worst part of town at certain points in their career. Well, the same can be true for PPE. If a situation emerges where one employee has better PPE than the other for whatever the reason, they might jam that, they might bundle that up into the matrix of whatever they're doing as far as a lawsuit at some point and say, well, this employee had better PPE, I had worse PPE, and the employer either caused that situation or allowed that situation in some way. If you ensure that all your employees have PPE, you can avoid seeing a claim like that later. And there was another one that was really, really smart, but I forgot what it was. If it comes back to me, I'll tell you. But basically, the costs can go up a lot higher on the back end if you don't ensure all your PPE is had by the employees. So I would go ahead and do it. I think it's a better move.
Thanks for that advice there, Jeff. We've run out of time on our Q&A session, but we have a wrap up here. So if you still have questions, go ahead over the next few minutes and still continue to submit them. All unanswered questions will be forwarded to Jeff via email and his all attendees in the coming days. So thanks to everyone who submitted those questions for today's session, and thanks to Jeffrey for taking the time to answer them. So Jeff, can you leave us with the key takeaways on government penalties and ensuring compliance?
Yes, I can, Stephanie. My pleasure. And thank you to you, and thank you to Leon and to the entire Personnel Concepts team for letting me do this today. I hope it helps our audience and our employers and businesses. And it was nice to have a chance to talk to everybody. Of course, I am available for more questions if anyone has them. Here's a couple key takeaways for employers to consider today. Take a closer look at your current practices to see if you're displaying the correct and applicable posters in the proper locations in your workplace where all employees and/or job applicants can see them. One way to avoid OSHA violations and citations is definitely proper training. Providing workplace training as well as identifying and addressing the workplace hazards you may have is a definite step in the right direction to ensure OSHA compliance and avoid fines down the road. As for record keeping, employers must keep records at the place of employment or in a central office or perhaps in a cloud or other type of digital database, and these have to be open for inspection by government representatives should they decide they want to do any inspection or audit.
Yes, thank you, Jeff. And can you also remind us of the information you covered about employee lawsuits?
Yes. As far as the kinds of employment law violations that can lead to employee lawsuits, employers should remember the following. Wage and hour lawsuits can get very expensive very quickly. Employers need to ensure their employees are classified correctly and that they keep the proper pay and timesheet records to show they are not skirting the minimum wage or overtime requirements. To avoid retaliation, employers should tread carefully around a protected employee complaint and that employee. Employers and their managers should try to avoid knee-jerk reactions and make sure they make no threats and take no worse than neutral or positive actions against the employee, witnesses, or anyone else involved. Finally, under the various state and federal laws that prohibit discrimination and harassment of specific protected classes, in relation to those, we want to always ensure that your workplace policies and training communicate that you have a commitment to anti-discrimination and anti-harassment.
Hey, thank you for reviewing that for us. And before we end today's session, I'd just like to remind everyone that all attendees will receive a follow-up email with a certificate as proof of attendance to today's webinar, along with a recorded video of this. And then within the next week, we'll get those answers from Jeff from those unanswered questions. And we enjoy hosting webinars for our valued customers, and as such, would really appreciate your feedback. Please stick around for a couple of minutes as a brief survey will open for you to rate what you saw and heard today.
Yes, and this concludes today's webinar. Thank you for attending our presentation. We hope you enjoyed and benefited from today's How to Avoid Lawsuits and Fines Tips for Employers webinar session. Thanks again to Jeffrey for participating as our expert attorney panelist. We look forward to continuing to working with you on future presentations, Jeffrey. And if you enjoyed today's webinar, We invite you to view past webinars on demand at the link posted on the screen. To all of our attendees, thank you for choosing Personal Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.